Finally, see, start. Even though the office has not raised an objection with regard to maintainability of the petition, this court, while hearing the learned counsel of the petitioner, raised a doubt whether at all a petition would be maintainable under section 482 of CRPC. Brief facts which necessary for disposal of this petitioner are as under. Petitioner herein filed a original suit in OS number 106 oblique 2011 on the file of two additional civil judge and JMFC 4 Raichur against APMC Raichur and others for the relief of declaration that allotment of plots in Rajendra Ganj Market Yard, Raichur is illegal. Inter alia, an application was filed under section 340 of CRPC wide IA number 11 to initiate criminal proceedings against the first respondent K. Vitthobhai, son of K. Uday Narayan, as he has intentionally given a false evidence before the trial court. The said application was contested by the first respondent and the learned trial judge, after hearing the parties, dismissed the application by order dated 17/7/2018. Being aggrieved by the same, the petitioner is before this court seeking quashing of the said order and allowing the petition. Insofar as the maintainability of the petition is concerned, Sri Mahantesh Patil, learned counsel for the petitioner, drew the attention of this court to the provisions of the section 195, 340 and 314 of CRPC. According to the learned counsel for the petitioner, the court is required to refer the matter to the concerned magistrate court after prima facie noticing that there is a false evidence adduced by a party to a proceeding, and direct the competent officer of the court to initiate criminal complaint for the offence of forgery before the jurisdictional magistrate. According to him, for exercising such a power, the court before which the false evidence has been adduced has got an inherent power and jurisdiction, and for which purpose every court can be considered as a criminal court. Non-exercise of such power by the trial court in the case on hand in dismissing IA number 11 is therefore amenable to inherent jurisdiction of this court under section 482 of CRPC, as admittedly it is a wrong order that has been passed by the trial court. However, since this court raised doubt about maintainability of the proceedings, learned counsel for the petitioner took time to make a research in this regard and make appropriate submissions. Today, he was fair enough to submit before this court that he is able to find out a judgment passed by the High Court of Kerala in the case of Sibbu George versus Jijiman and another in criminal miscellaneous case number 8438 oblique 2018 dated 10/1/2019. The copy of the said judgment is made available by the learned counsel for the petitioner. The relevant portion of the said judgment reads as under. Section 340 CRPC prescribes the procedure to be followed in the cases mentioned in section 195. The application should be filed in the court in which the proceedings in relation to which the offence was committed were pending. Subsection 4 in section 340 provides that in this section court has the same meaning as in section 195. Section 341 of the code reads as follows: any person on whose application any court other than a high court has refused to make a complaint under subsection 1 or subsection 2 of section 340, or against whom such a complaint has been made by such court, may appeal to the court to which such former court is subordinate within the meaning of subsection 4 of the section 195, and the superior court may thereupon, after notice to the parties concerned, direct the withdrawal of the complainant, or as the case may be, making of the complaint which such former court might have made under section 340, and if it makes such complaint, the provisions of that section shall apply accordingly. An order under this section and subject to any such order, an order under section 340 shall be final and shall not be subject to revision. In MS Sharif versus State of Madras, an application was filed under section 475 CRPC requesting the High Court to prosecute two police officers for perjury under section 193 IPC. The facts of case are irrelevant. The question raised before the Supreme Court was in which court an appeal should be filed against the order passed by the Division Bench High Court. The court took notice of the relevant portion of the provision section 476B of the old code relating to apply, which reads as follows: stuff.